Hi, this is Cora Stack here. I just wanted to talk about the following. Is it time to consider a new model of justice for minor or first offences? Just reading the papers today, it's clear the present impasse between the Minister for Justice and criminal legal aid solicitors in Ireland raises important questions not only about legal aid fees, in my opinion, but also about the wider operation of Ireland's criminal justice system. So I've been thinking about this for a long time. Criminal legal aid solicitors perform an essential role in protecting the rights to a fair trial, particularly for vulnerable people who could not otherwise afford representation. But there is a huge amount of people in the squeezed middle who are in the exact same situation who are denied legal representation. So we have a huge access to justice problem. And this has been articulated by many senior judges and ordinary judges. And at the same time, the state has the legitimate responsibility to ensure that public money, our taxes, is used efficiently and that unnecessary delays are reduced. A fair resolution should or could recognise both concerns. Now, the dispute already creates an opportunity, I think, to consider whether Ireland is using imprisonment appropriately. My understanding is that prisons are overcrowded and that it costs more than €100,000 per year to keep one person in prison. I mean, that would go to buying a house or an apartment for a lot of people, would it not? Prison remains necessary for serious, violent and dangerous offending. Unfortunately, at the present time, we don't seem to have an alternative. The safety of victims and the public must, of course, come first. However, for certain types of offences, first or minor offences, where there is a prospect or a reasonable prospect that this person will not become a repeat offender, the question can be asked, should the justice system, could they consider structured alternatives to imprisonment? This should not simply allowing someone to walk away without consequences. I feel this is happening far too often. There's no consequences. There's just, you see someone with 80 previous convictions, and you don't hear what has happened between those convictions. I mean, I don't know, perhaps the reason the judge doesn't have doesn't have any, what his powers are in this regard. Alternatives could include formal cautions, community service, reparation for harm caused, restorative justice where appropriate, education, addiction treatment, mental health support, and close probation supervision. Now, some of those are in place at the moment, but not that. The aim would be to intervene early, encourage responsibility, and reduce the risk that a relatively minor or first offence develops into a repeat pattern of offending. You hear so-and-so has 85 repeated offences or, previous convictions. I mean, the amount of that's going on is incredible. And we don't see the repair or any in between that these are being required to do community service or, give anything back or anything that would help them learn from their errors. So a balanced, just letting them out and giving them no education about what they've done or therapy doesn't seem to me to be a good way of dealing with these things. A balanced model could combine accountability with rehabilitation, public protection with compassion, and legal fairness with practical effectiveness. This is just a particular perspective. The important question is not simply whether a person should be punished. Again, I'm saying we should go from punishment to healing, but not not irresponsibly. Is it what form of justice is most likely to prevent another offence, recognise the harm caused, and help the individual develop greater respect for others, for the community, and for the law? Could a more structured, proportionate, and humane approach to minor or first offences lead to reduced recidivism and a more compassionate society?